But we have quarrels with other issues, voting through the back doors and ventilators and injected into the bill.
The issue is that the moment those provisions were introduced and they had the financial implications, it would now become, the government should have taken it over as a government bill if it wanted it to continue.
Yes, my lords, but when you
and having failed to do so, it would not have been passed into law as a private business. That's the important.
Our submissions, my lords, we haven't reached the stage of final submissions. That this entire act is fatally flawed. Why? There must be a reason for the many reasons, including some of which we have so far abused. Okay. In the alternative, that those provisions of the Act which are inconsistent and in contravention should be declared so by this honorable board.
Inconsistent with Article 93.
Yes, my lord. And that is the nature of our final submission. We have not made it yet, but that is where we are going.
Thank you.
So on this issue, my lords, I wish to conclude. I know it is a very interesting issue of discussion, but my lords, in conclusion,
all of them are. All of them are very interesting.
Obliged, my lords. I know, in conclusion, my lords, I know that they say that your lordships do not make law, that judges don't make law, that you only interpret.
We do. We make law.
But in practice, you make law.
But in the rarest of rare.
And we all know it, although we never admit it.
Okay.
Here at the bar, we are always hanging on your words. And even government is always waiting for your interpretations. So in this case, my lords, I wish to rest by saying that you interpret Article 93 in a situation where a private member's bill has completely deviated from the certified objectives and uphold the intention, the purpose and intention of the makers of this act, which would be that where there is such deviation, the certificate itself is a nullity, and any bill which proceeds to enactment on such basis is a nullity itself. We beg to rest, my lords.
Thank you so much. Yes, Mr. Mbale.
My lords, Mr. Mbale.
Okay, Mr. Mbale.
Thank you, my lords. My lords, as I begin, can I?
Yes.
My lords, on this issue, maybe I don't want to be viewed as opposing my fellows, but I just want to clarify, to make some information on the answer.
In what period of time?
We are not fellows.
Okay, Mr. Mbale is a lay person, so we can understand. He's using fellow in a very positive term, that you belong together in challenging the Attorney General for the actions of his agents. So in what period of time do you want to clarify?
This is just 1 minute, then I go to my submissions.
And it will all be together?
20 minutes.
Really?
Yes, my lord, because we shall see that I have a divergent argument.
Okay, begin. The whole of it in 20 minutes.
20
your
minutes.
clarification, your submission, 20 minutes.
I just want to take you first at page 5251 of the answer. 5251. I'm making it clear that at that page, Mr. Tusime, who introduced all those new clauses at the floor of Parliament when they were at the committee of the second stage, he stated, it is 5251, Madam Chairperson, permit me to lay on the table a certificate of financial implications and a copy of the proposed amendment. I beg to lay. So from reading the Hansard carefully, there was indeed a certificate.
Which volume of
My Lord, the discovered document.
The Hansard?
Yes, the Hansard. That the last of 20th.
which band of
This volume of discovered documents. The documents are produced by the Attorney General. I don't know whether it's true, but any Hansard which maybe you can also use that of petition number 13. It also has a Hansard.
But you were saying when this other man made a statement in Parliament, the one who produced the amendments.
Yes, they challenged him on the certificate, and he laid it on the table.
He laid it on the table.
Yes. I was clarifying that because the common position was maybe there was no certificate. That second certificate. But the answer shows that he actually laid a second certificate.
A second?
Yes. A second certificate after introducing the amendments on term limits, what those new ones. He laid on the table a second certificate.
Which covered the amendment?
Aha. That was the clarification of mine.
How do they write aha in the recording?
How do they?
How will they write it? Because whoever is reading will think you are laughing. When you say aha, because this thing is being recorded,
I think I should say yes.
I think you would have said yes.
I'm obliged, my Lord. So, my Lord, that was the clarification. But for me, my argument is this.
So, Mr. Mbale,
Yes, my Lord.
second certificate covering the amendments was tabled.
Yes.
Do we have it?
What's the page of the Hansard?
From the 5251, proceedings of 20th December.
Was it one of the documents you asked for?
Yes.
The discovered?
Yes.
And then was it conveyed to you?
Yes, my Lord. The Hansard.
The
Not
Hansard.
the Hansard, the second certificate.
The second certificate.
No, it was not availed.
Did you request for it?
I didn't because I thought it wasn't there. But on reading the Hansard, he was challenged so much. So he said, I have it and I'm laying it here. And then the matter went to rest.
Okay.
So I was just clarifying.
So in other words, you are throwing spanners in your colleagues'
I'm
work.
clarifying the record, my Lord.
Yes, but the clarification throws spanners in their works.
But my Lord, my line of argument on this issue is this.
You are helping the Attorney General on that point.
I didn't want him to come to show that he's the one who saw this.
So, okay, I've reduced the time of the Attorney General by about 3 minutes, which you extend.
My Lord.
Anyhow, please
So, my
proceed,
Lord,
proceed, yeah.
for me, my argument on this issue is that in light of Article 93 of the Constitution, no action whatsoever ought to have been taken by Parliament in respect of this bill. Not even the application for leave to introduce it, because that was a motion which is prohibited. Not even the leave itself, and not even any other step. Because the provision of Article 93 is clearly prohibitive. It says, don't touch this line, it is hot. My Lord, the Parliament we are having in this country is subject to the Constitution under Article 79. It is not an absolute Parliament. It's a Parliament which is subject to the Constitution. So this Constitution has some limitations on what it can do. And one of the limitations is in Article 93. It says don't even move a motion. Don't even move an amendment. Don't do anything.
Does it say that?
Yes, my Lord.
That don't even move a motion?
Yes. If I may read Article 93. A, it says Parliament shall not, unless the bill or the motion, it's not even a bill, or the motion is introduced on behalf of the government. When you go to B, that's the General 93A, proceed upon a bill including an amendment to the bill that makes provision for any of the following. 1, Roman 2, I'm skipping 1 because I'm not sure. Roman 2, the imposition of a charge on the consolidated fund or other public fund of Uganda. Roman 3, the payment issue or withdraw from the consolidated fund. And B says, the effect of which would make provision for any of the purposes specified in paragraph A of the article. So the framers were very specific. They prohibit a motion, they prohibit the law, and then the effect. So this was a no-go zone in any case. And my lords, Rule 123.1.
So what impact, if any, would moving a motion seeking leave to lodge a private member's bill, what financial implication in just seeking leave?
My lord, it is a prohibition. The Constitution says it prohibits even motions, not only bills.
No, it doesn't say like that. You're the one who just read.
My lord, I've just read it.
No, listen. If we listen to one another, we will move. Because I'm sorry what you're saying. You seem to be segmenting the reading of this, and yet it's disconnected. Let us narrow it down to a motion, because what happened was a motion.
Yes.
There was a motion seeking leave to introduce a private member's bill. And that provision of the Constitution, yes, says not even a motion. But it goes ahead to say, if it is a private member's motion, then it can only be gone into when there is a certificate.
My lord, that's not in the Constitution.
Listen. It says if it has financial implication.
That's not in the Constitution.
Read it again. Read.
My lord, let me read this properly.
Yes.
Parliament shall not, unless the bill or the motion is introduced on behalf of the government.
Yes.
Then this is those circumstances. It comes to A. Proceed upon a bill, including an amendment bill, that makes provision for any of the following. Roman 2, imposition of a charge on the consolidated fund or other public fund of Uganda. Roman 3, the payment, issue or withdraw from the consolidated fund. Part B, the effect of, Part B, let me read all of it. It says, proceed upon a motion, including an amendment to a motion, the effect of which would be to make provision for any of the purposes specified in paragraph A of this article.
Yes.
So, my submission is, this issue of certificate of financial obligation is not in the Constitution. Actually, when they bring it here, they are amending the Constitution. They are saying, except as may be certified. But the Constitution does not ask for certification. It says, no, don't go there. Don't go there. Now, what they did, they passed an act, Finance Management Act, then under Section 76, they try to maneuver around so that they can have someone one day come up and say, I have a certificate. But this article...
Are you saying that act is inconsistent with the Constitution?
This article and Section 76 is null and void. If it's not null and void, it then only applies to government ministers. And my lord, when you look at Rule 123.1 of the Rules of Parliament, 10th Parliament, I reproduced it at my index 141 in my white volume 2. For it is specific. It says, no question shall be proposed upon any bill, motion or amendment which has not been introduced or moved by a minister. So the article talks about government. Here they are clear. It must be the Article 93 talks about government. Rule 123.1 of the Rules of 10th Parliament talks about a minister. So this time in the rules, they make it clear that by government we mean...
Say Rule 1.
Rule 123, sub-rule 1.
Of what?
Of the Rules of Parliament.
Rules of Parliament.
Yes, my lord. For it is specific that no question shall be proposed upon any bill, motion or amendment which has not been introduced or moved by a minister. Then it lists.
But that's common sense. When government moves a motion or a bill, it's done by a minister.
Yes.
Yes.
My Lord, some Majesty may say I'm also in RM is in government.
Come again?
Honorable Majesty may say I'm also in RM is in government.
Then even the opposition can say, because even the opposition are in government. Once you're in parliament, then you're in one of the three arms of government. So even the opposition,
so my Lord, after that,
the leader of opposition, member of opposition, just like member of government, the independents, they are all in government.
Yes, my Lord.
Yes.
So after
this thing about ruling party is a misnomer.
My Lord. So yes. after this saying a minister, they reproduce all the provisions of Article 93 in Rule 123. They reproduce the entire article. They only add one thing. Instead of government, they say a minister. So my Lord, it is clear from this constitution and the rules of parliament that Honorable Majesty would have been locked at the door, not even entering parliament with his motion. The moment the speaker looked at it like this, and my Lord, the speaker had done it before, and his first mentioned that she was stopped from allowing Majesty, yet she had prevented other members. My Lord, let me take you to the Hansard at page 4698, which is those are proceedings of 26th September 2017. My Lord, the Hansard which the clerk provided has no these numbers. It was not yet in the bound, but there is a Hansard for petition number 13. It has already numbers. But the speaker said in her opening remarks,
Proceedings of?
The proceedings of 26th September 2017. She stated, my lords, that it should be noted. No. She stated that for a long time we have been demanding that government presents in this House constitutional amendments, but they have not done so. I do not know how long I can continue stopping members from bringing motions. Now that the government has failed, members should proceed and bring the motions so that we can do our part. And they applauded her. My Lord, this was unconstitutional. The speaker was amending the constitution, because the constitution says government shall introduce. Maybe government was not interested in that part. Would the speaker force government to bring a law which is going to charge Ugandans? So it's my submission, my Lord, that this speaker, under section 114 of the Evidence Act, was stopped.
I don't think a stop of that, but the question as to whether or not a motion, a bill, an amended motion is in compliance with Article 93 would require a certificate, in my view, saying no financial implications.
My Lord, I disagree.
I am not arguing with you. I am not arguing with you. So, otherwise, as to whether or not Article 93 has been complied with, would constantly be a question of debate. And I think you need a body that finally determines whether or not that is the case. Because where you have, for example, like you have just said, where you have a private member saying this bill of mine has no financial implications as set out here, and the speaker says it has, what happens? Every time a private member brings a bill, the speaker says it hasn't. What happens? That's why a certificate is required, so that that fact is determined by that certificate. But I don't think that the certificate has to explain that the money is there. It simply has said it has no implication. I can give you an example. In 1979, when Amin was overthrown, there was a law passed by the National Consultative Council, and it was called Obnoxious Laws Miscellaneous Repeal Statute. Now that law just repealed all Amin's obnoxious laws. I think such a bill would have no financial implications. So yes, there are certain acts of parliament that have absolutely no financial implications. But where the issue is whether this one side says they put, another side probably not,
My Lord.
And just to add on,
yes,
in the present one, the certificate that was issued, the minister said that this bill was budget neutral.
My Lord, to answer you, if that minister really felt that there was need for this law, the Constitution tells him, table it in Parliament. Why is he hiding behind some?
When the private members keep up with the bill?
My Lord, the private members can bring a bill as long as it does not contravene the Constitution. As long as it does not contravene Article 93.
When will private members ever bring a bill that complies with 93 under what circumstances?
At one time, someone may bring a bill which does not contravene 93. For example, when you say,
under what circumstances?
for example, if you want to say that people should start home, probably at night, and you want that to be a law, that may not be contravening 93.
What about workers who work at night in factories, nurses, petrol stations?
Now, if you bring that dimension, then it's also prohibited. But the purpose is, it should be the government which people elected to introduce most of the laws. That's the purpose of elections. Not someone walking from behind and says, I have this law. I want the age limit to be removed.
You made that point.
Yes, my Lord. So I'm moving on to the authorities. I have two cases to support this. The first case, my Lord, is Attorney General versus Mbale. It's at my index 399. That is Supreme Court Constitutional Appeal number 3 of 2004. In that case, the decision was unanimous by the Supreme Court. And at my index 399, they said, the passing of the Act on 7 June 2000, therefore, was in contravention of and inconsistent with Article 271(2), because, contrary to the time prescribed in that article, the Act was passed long after it was due, and it sought to abridge the period for canvassing for purposes of referendum. In that case, my Lord, the Constitution was clear that you don't make a law after 2 years before the next election. Parliament let the 2 years pass, and then at the end, when elections were clocking, they passed it. The Supreme Court is saying that was contravention of the Constitution, and they struck out that law. The second one is the United States decision at my index 214 of volume 2. It is Citizens United versus Federal Elections Commission. In that case, my Lord, the Congress of USA passed a law saying that companies cannot sponsor campaigns of candidates, and was challenged on the basis that it was infringing on the right of speech. And the focus was on the Second Amendment of the American Constitution, which was clear that Congress shall make no law abridging the freedom of speech. In that decision, Justice Kennedy, at my index 214, held that the First Amendment provides that Congress shall make no law abridging the freedom of speech. The law before us is an outright ban, backed by criminal sanctions. For Chief Justice Roberts, at my index 3.2, at volume 2, page 13, he held that this theory, if accepted, would empower the government to prohibit newspapers from running editorials or opinion pieces supporting or opposing candidates for the office. The court properly rejects that theory, and I join its opinion. My Lord, if you uphold this law, you are going to create a very bad precedent where the Constitution is going to be undermined. People move from the backyard, come to Parliament, say we have this law. And getting a sort of financial application is such easy. If indeed they see they want it to be so, to have provided so. Just like I've just read to you, he got a second one in nominati, and he presented it. So, my Lord, I'm now proceeding to show you how the law before you and the bill has an effect on the consolidated fund.
How much more time do you need?
My Lord, 10 minutes. Just to go through the laws.
Conclude the laws and fire. You've gone way beyond.
Hold on, my Lord.
Yes, gone way beyond. We're already 30. So I'm giving you 5. Sort it out.
My Lord, I'm going to rely on section 9.2. 9.2 of the Electoral Commission Act, Cap 140. It's at my index 404. It provides that all money is required to defray all expenses that may be incurred in the discharge of the functions of the Commission or incurred in the purposes of this Act are charged on the consolidated fund. So by providing for elections, how they should be conducted, you are going to the consolidated fund. My Lord, section 20 of the Administration of Parliament Act, it is Cap 257. It says, the administrative and operational expenses of Parliament, including salaries, allowances, gratuities, and pensions payable to or in respect of a person serving in Parliament, shall be charged on the consolidated fund. My Lord, Article 128.5 of the Constitution provides that the administrative expenses of the judiciary, including all salaries, allowances, gratuities, and pensions payable, are chargeable on the consolidated fund. My Lord, lastly, second last, Article 100.063 of the Constitution provides that emoluments of the President are charged on the consolidated fund. And lastly, Article 193.1 provides that the President shall, for each financial year in accordance with the Constitution, cause to be presented to Parliament proposals as to monies to be paid out of the consolidated fund to local governments. So surely when you look at the entire bill, it involves matters which are going to the consolidated fund. So my Lord, this Parliament was actually warned that they were going into a danger zone. And that was Nandalama Fabi Honorable at page 5139 of the answer. He said, Madam Speaker, one of the things which has been emphasized and which I know, Madam Speaker, you have done, and which the first Speaker also did, concerns Article 93 of our Constitution, which says, he mentioned it, but the Speaker never left him to finish. The Speaker said, Honorable Member, there is no bill. We are dealing with the report. No, there is no bill at the moment. We are dealing with the report. Honorable Mafabi again remained and said, Madam Speaker, the information I'm giving you that a referendum is a charge. So Honorable Mafabi was silenced, but my Lord, I refer you to the decision of Oroko Nyango. That's that one again which I referred earlier at my index 411, that the Speaker is obliged to uphold the Constitution and the rules. And where she is alerted and she does other things, then this court is left with no option but to set aside this law, my Lord, which has brought us before you. So my Lord, with that, my conclusion is, if you are looking for any issue which may determine this entire petition, is issue 6A. Because under issue 6A, Honorable Majesty could not even near the door of Parliament with that paper. She was closed out from outside.
You say if we are looking
for any issue which is going to determine this petition at the preliminary level, without even going what they did. But my point is, this issue takes away each and everything which was done. It nullifies all the proceedings that took place after the introduction.
You're saying it was null ab initio?
Yes, my Lord.
From the very beginning? From the very beginning.
It was a nullity. In confirmation of Article 93, on the basis of those two authorities of our Supreme Court and the USA Court, my Lord.
Thank you.
Thank you, my Lord.
Okay, thank you so much. Mr. Ogado.
My Lord, I pray for just 3 minutes to link
evidence from petition number 3 to buttress the arguments which have been made about 93.
Granted.
My Lord, I refer to the affidavit of Professor Sempebwa, sworn in petition 3, paragraph
That's right. On the list of authorities?
no, the petition itself.
No, the petition.
Petition 3. Affidavit of Professor Frederick Edward Sempebwa.
On top what?
Beg your pardon, my Lord.
What page was
What
that?
page is it? Which tab is it?
My Lord, it is, my apologies, my Lord, it is, was not
But you have these stickers. Which one?
it is paragraph 8 of the affidavit of Professor
No,
Sempebwa.
where do we get it?
It is in the bound volume.
In the petition itself.
In the petition itself.
But where in the petition?
GS2, the next document, GS2.
Yes, my Lord.
GA
GS2,
or the next one?
the next document.
Next document. Mine says GA2. I have
The
GA2.
next document.
What is GA2? I have the report of the second committee. Also, in mine, it's not like that's the Mr. Mbale, you didn't think I should have that affidavit.
My apologies.
It's not in my... We found a key.
I really thought you should have one, my Lord.
I do have it, but you've hidden it elsewhere.
My apologies, my Lord.
The original or after
No,
No, in the support. In the support.
This was just Thank you. We are there, Mr. Mbale.
Obliged, my Lord. My Lord, the paragraph 8. Paragraph 8 begins from A, but I'm referring, my Lord, at page 17, where there is O.
Page 17 of the affidavit.
Yes, my Lord.
Where there is 4?
O.
I don't see 4.
Not O. O, my Lord.
O.
Yes, my Lord.
Ah. O as in organ.
Yes, my Lord.
Okay.
Where he states that the holding of presidential elections at the same time as the parliamentary elections, where both the presidential and parliamentary terms expire at the same time, enables the Electoral Commission to organize the said respective elections at the same time without incurring double resources at the expense of burdening the taxpayer. Then, my Lord, he attaches on that affidavit P2. He attaches on the affidavit annexure P2. And annexure P2, my Lord, I refer your Lordships to page 7-86. And my Lord is giving the views of the people of Uganda during the time of the Constitutional Review Commission, when he was collecting with his commission's views of what the people want. And clearly the views of the people is that the timing of presidential and parliamentary elections should be at the same time, and at the bottom of page 7-84, where the paragraph 60 says cost is a very relevant consideration, up to the next page, ending at the end of the first paragraph, it shows that when you have elections at 2 different times, for presidential and parliamentary, the Electoral Commission will inevitably have to have extra costs. There are others which can be duplicated, as he said here, but there are some which cannot be duplicated. So since we are going to have elections in 2021 for presidential, and for parliament according to this law, 2023, it means the holding of 2 general elections at two different times.
Could be near to the microphone so that we are sure it is properly.
Obliged, my Lord. My Lord, since we have...
Just a moment. Are you okay there? Proceed.
My Lord, since according to this Act, parliamentary elections are going to be held in 2023, but presidential is going to be held in 2021. It means we are going to have 2 general elections. The one of the president and the one for parliament at different times. Therefore, the Electoral Commission will have to spend twice the time. That will mean, therefore, that more money will have to be charged on the consolidated fund for the second general election. And therefore, in my humble submission, Article 93, the effect of Article 93 now and the bill is really to charge the consolidated fund, that is the effect, to charge the consolidated fund with extra money which would not have been incurred.
You could even go further by saying even if one tries to cure the disparity, disparate dates between parliamentary elections and presidential elections by holding a referendum which merges them. The very process of going for a referendum is already a charge in the consolidated fund, which is subsequent or consequent upon this enactment.
Most obliged. So, my Lord, since it is clear that there is a charge under the consolidated fund, this bill should have been brought by government. A private member bill and a private member cannot bring a bill whose effect is to create that charge.
But Mr. Ogalo, Mr. Mabirizi, I have not looked at the record. Mr. Mabirizi said there is something which maybe you did not see, that there was a certificate at the beginning and a certificate prior to the amendment, or when they were amending, there was a subsequent certificate permitting, if you allow me.
No, my Lord, for me, I will answer that with the words of my Lord Justice Kapuru, that as soon as you charge, as soon as a private member, as soon as a person who is not government brings a bill which charges the consolidated fund, that closes the matter. It becomes unconstitutional. Because he does not have that.
If I understood Mr. Mabirizi saying, before they discussed that bill, there was a certificate. And then, same for the amendment. The amendment did not come and close, it was closed with that certificate.
Yes.
That's how I've not read it myself.
Yes.
And I'm just relying on it.
My Lord, I want to separate the two. There is a certificate. The fact that you have a certificate is different from the right to charge a consolidated fund. Those two are distinct.
I'm not with you. I thought the purpose of a certificate is, in other words, a certificate permitting Parliament to proceed. The certificate doesn't say, because this is charging on the consolidated fund, you cannot proceed. If the certificate says, yes.
No, my Lord, my understanding of it is different. But under 93,
Yes.
it is just absolute. The private member of Parliament will not bring a bill which charges the consolidated fund.
No. I don't know. I thought it says if.
Depending when there is a certificate. Yes, my Lord. Even if there is a certificate.
But if the certificate says, Mr. Ogalo,
yes,
if the certificate says there is no financial implication, because Article 93 flows something or paragraph something says, where it has financial implication. Who is the best person to say it has no financial implication? Isn't it the fellows in charge of the granary of money?
But I think that's true. The fund, the certificate would resolve the problem, but it's not final. It is subject to challenge because it's just prima facie. If a certificate says there's no charge, I think it is still open to challenge if it's apparent that there is a charge.
Yes, my Lord. Obliged, my Lord. Because under paragraph
and there's
B,
nothing to show that a certificate, and such a certificate shall be taken to be final and conclusive as to whether or not they will not be charged.
No.
So what is your argument? That there were certificates, despite those certificates, as you are arguing, the fact that you have to do this and this, contrary to what the certificate says, there is a charge. Is that what you're saying?
That's what I'm saying, my Lord.
Not that there was no certificate.
That there is an effect, that the effect is to create a charge, and that there will be extra costs.
It is clear from the face of it. Is that what you're saying?
My Lord,
just a moment. I'll allow you to say. I just wanted to know what the argument. You remember I said Mr. Mabirizi had thrown spanners in your works. So I really want to know what the argument that there are certificates, yes, but despite the certificates, there is financial implication. No. Then allow the Attorney General probably say something and you respond at once. Or are you saying there were no certificates?
My Lord, from what I've heard from Mr. Mbale, he has read from the Hansard.
Yes.
to say that somebody stood up, called him honorable to see me, and he said, I'm tabling the certificate. I've not seen.
Is that answered one of those public documents the courts have to take issue notice of?
It is, my lord, but like my lord, we have had documents in respect of that produced. Documents with the batteries, which support.
No, the record is saying there was, unless of course your case was that there was no such a thing. There is evidence that I was in Parliament. Nothing like that happened.
But my lord would need to see what are the contents, what were they covered. That can only be done when I have sight of that.
You did apply for discovery.
My lord,
yes, this is your case. You're the one challenging. If the document is in the possession of the respondent, the law is clear. You apply for discovery. If you're not contented with the information in the parliamentary proceedings.
If I may assist my senior, the respondent filed the answers. And in those answers, the Minister of Finance certificate of implications for this bill were attached, annexed.
Yes.
The one in the case of petition number.
How many? Was it one or two certificates?
It is one, my lord, annexed by the PSST.
Yes.
When you compare that, the draft parliament is again one.
Yes.
So those are the certificates, financial implications, tendered in evidence by the respondent in this case.
You see, the issue, I must repeat this, is the principle. The principle is that there should not be a charge on the consolidated fund when a private member brings a bill. Yes. To resolve that, whether there is or there is no charge, the certificate is issued. And now, a law that brought in the operation of the certificate was to resolve the debate whether there is a charge or there is no charge. But it's not final. Because that's what the Minister of Finance says. The Minister of Finance is not the alpha and the omega to determine whether there is a charge or not. Suppose there is a charge, and the Minister says there is no charge. Does it stop the charge?
Once you bring evidence, or if you can argue that on the face of it, like I think this is what we were saying, Mr. Ogana, that even if there are certificates, from the evidence, there will be need to go for referendum to bring these things into parity. And that alone is already a charge on the public. Yeah, then that challenges the certificate. Or else you have to bring evidence. Because that one is on the face of it. You're saying it challenges the certificate. I think that's what my lord is saying. Yes, let me act on the general.
My lord, that is where you are coming in. I was constraining myself from interfering with the submissions of my learned friend, Mr. Gallo. He has now shifted from being counsel to being a witness to tell us that notwithstanding whatever would have been contained in the certificate of financial implications, he knows that if there are elections here, double elections work, there will be the financial implications.
Learned Attorney General, that's what he said. Please, I agree. Please, you hear me out first. That does not turn Mr. Gallo into a witness. The argument being tendered by Learned Counsel Wandera Gallo is that yes, there is a certificate. That's why I sought clarification. But any person looking at what these documents are will discern that in order to arrive at the logical conclusion, for example, you have to go through a referendum. And once you bring in a referendum, it actually contradicts the certificate. That is an argument. Because a referendum is a charge on the consolidated fund. That's really what Mr. Ogana is saying. You don't have to be a witness. You see it from the record, face of the record. That's
and my Lord, Mr. Ogana referred to evidence by way of affidavit of Professor Sempebwa. Yes? And Professor Sempebwa's affidavit, I have it here, is the one that imports the cost, because Professor Sempebwa refers to the report of his commission made in 2003, which, unless It states clearly the affidavit of Professor Sempebwa in the annexed to it, page 76 says, it says that cost is very relevant consideration. Although democracy is said to be expensive, a poor country should save money whenever possible. And analysis funding parliamentary elections, etc. So, Professor Sembe appears in his affidavit to have stated that. Maybe that's what's
Anyway, so if that's how we understand the submission, Mr. Mbale. I think it is two-pronged. It's challenging the validity of the certificate, but his colleagues, as his learned friend, Mr. Jamoham, has helped him, saying they actually attached two certificates. And I went a notch higher, saying the record, which the court is under duty to take judicial notice, the parliamentary proceedings. This one need not be proved because the law said we take judicial notice. Clearly states, and this was discerned by Mr. Mbale, that there was a second certificate. Although it has not been attached, but it speaks of it. Nobody has disputed it, nobody has controverted it, but that's what the record says. So if there is a certificate, then you're left with the other argument, that despite the certificates, we can prove that the certificates have no value because of this. That's how we have understood it, Mr. Mbale. Any other thing you want to say?
No, my lords.
We've done it all for you.
You have done it. I'm also
Thank you.
my lords.
Okay, so thank you. Yes, so is that all for 6A?
Yes, that is all for 6A. Mm-hmm. My lords, we had thought that he would also deal with the 11th.
Yes.
But my lords, after discussions, it was found that some of the council really needed the evidence coming out of cross-examination.
For 11?
For 11, 11 and I think for the 11 and 12.
Whose evidence? Whose evidence?
We have 11 and 12?
Yes, my lord.
Whose evidence?
Mr. Mbale, what evidence do you need this? In this number 11, let's begin with number 11.
Whether Section 9 of the Act, which seeks to harmonize the 7-year term of Parliament with the presidential term, is inconsistent with or in contravention of Articles 105, 1 and 2602 of the Constitution.
Which evidence would anybody provide? This Mr. Wakafus.
So we applied for the cross-examination of Mr. Mitara.
Come again?
We applied for the cross-examination of Mr. Mitara.
Of Mr. Wu?
Mitara.
Yes, what is about what? How does it relate?
About Section 9 of the Act?
Yes.
So please, you are going to submit.
What does Mr. Mbale say that is on Section?
He was not even in Parliament.
No. It's one affidavit on how government is preparing to harmonize the two.
No.
Yes.
Okay, it's preparing to harmonize.
Yes.
But how does that contravene 105 and 260?
No, but you see,
105.
the reason why Mitara
105 is the tenure
Yes.
of president.
Yes.
And 260 is
105 requires a referendum.
When can you answer that? What does that issue tell us? When can you answer that? That's exactly like what was urged in the morning. That the import of this would be to directly amend 260, which requires it. Why does that need to start that?
My lords, we applied and you allowed that those people be summoned, then otherwise you can
but you did not tell us, Mr. Rwakafuzi, Mr. Rwakafuzi, nobody is stopping you from cross-examining the people you applied to come for cross-examination. You never told us you want to cross-examine Mr. Mitala on issue number 11.
We did not tell this court on what we're going to cross-examine.
You tell me, is issue number 11 a question of point of law or not? Read it. Maybe you've not read it. Read
all
it out.
Our issues are
would you like to read it out, please?
Where is the act with the small a that imports facts? The act with the small a. The act of so and so that is required.
The report of Mr. Mitala.
You didn't see it.
The report of Mr.
Look at issue number 11, where the section of the act. You see, if there was any import of any issue of fact, then that issue of fact would be apparent in that issue.
And when they did this, if there is any issue which is exclusively a point of law, number 11 is one of them.
My Lord, why we did Mr. Mitala? He attacked.
Who said you don't need it? You're the one who said we have allowed you. We even made it very easy. We even bent backward. And you should have seen the face of the Attorney General. When we bent backward to accommodate you, when on the authorities we should have rejected, we bent backward, then fine, let them come and you cross-examine them. But that does not make issue number 11 a matter of law and evidence. Please, no. You're the ones who proposed these issues and court adopted them.
You see,
we don't want to stampede you, but we also don't want you to stampede us.
Mr. Rwakafuzi,
yes, my Lord.
Would you like to start submission on issue number 11?
No, my Lord.
You're not ready.
I'm not ready. I have to cross-examine Mr. Mitala on his affidavit. He has
on what? On issue number 11?
He has extensively made a roadmap on how the referendum will be made. Will be.
But issue number 11.
What has that to do with Article 260?
Issue number 11 is saying Section 9 of the Act is inconsistent. Not that the action of the Mitalas of this world is inconsistent. Section 9 of the Act is already existing. It's not a future event.
Then after we have cross-examined the hill, what shall be done? Why are we doing two things at this? Why are we duplicating these proceedings?
The question is, why are you here when you are not ready? Why are you here? You have been here since Monday, you have not said anything. Why you have given an opportunity to proceed?
Because this is what appears to us. Because you are not ready, you want to hide under some flimsy excuse. Oh, Mr. Mitala has not been cross-examined.
No, my Lord.
Do you want to cross-examine Mr. Mitala? Please listen to me. Would you please like to listen to court?
Yes, my Lord.
Do you wish to cross-examine Mr. Mitala on Section 9? How Section 9 impacts on Articles 105 and 260 of the Constitution? Is that what you want to cross-examine Mr. Mitala about? No. It's obvious. That is not what you want to cross-examine him about.
And you see, Mr. Rwakafuzi, if after cross-examination any other issues come up, you have opportunity to resubmit. You'll be given that time. After that, any other issues that come after cross-examination, you'll still be given more time. But at least let us cover that issue to the extent that it does not require the evidence.
I thought your cross-examination of Mr. Mitala would have supported your argument in 6A, the one we've just finished, where I think Mr. Mbale was saying this thing, despite the certificate, has financial implication. Now Mr. Mitala is even going to say that, yes, we're making preparations for this and that. It is in his affidavit. You went ahead and submitted on 6A, where this would be relevant. Now you're importing what is not relevant in 11 simply because you're not ready in the hope that the court will concede. The court is not. You're going to submit unless you're forfeiting issue number 11.
My Lords, this is my understanding of the unconstitutionality of Section 9 of the Amendment Act.
How much time would you need, Mr. Wakafu, so that we...
A short period, because...
No, there's no, you see, it's in digits.
My Lords, it will be 20 minutes.
20 minutes.
Yes.
Granted.
My Lords...
Just a moment, please. Do we have the petition of Mr. The one is going to submit? Which petition is it?
Number 5.
Number 5. Just one minute. So that we move together with you. This will apply to issue number 12 as well. Come again. It applies the position that issue number 11 will not await any cross-examination applies to issue number 12.
My Lords, can I begin?
Yes. Please. I'm beginning to count your minutes now, yes.
My Lords, under Article 79 of the Constitution, Parliament make laws. And when a law is made, by definition, a law gives liabilities, rights, obligations. A law, by definition, under Article 79 of the Constitution, cannot be suggestive, that we suggest, and even put it in an act of Parliament that we suggest that the canon be there. You see? Because when you look at because what this Section 9 is saying is that, let me read for you. Article 2, the insertion of Article 289A. Clause 2 of Article 105 shall come into effect upon the dissolution of the Parliament in existence at the commencement of this Act. No, the manner in which this matter is quashed is as if the results of the referendum are already known. My Lords, this is contrary to Article 1 of the Constitution, because the people could reject it. So, Parliament cannot just make a suggestion. It does not have that right under Article 79 of the Constitution. It can only pass motions. During motions, in motions they can make suggestions, but not in an Act of Parliament. An Act of Parliament must be binding, must be for a given effect. Now,
supposing it had said, Mr. Wakafu, if it had said subject to a referendum to be conducted within this period, blah, 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 would it be good law?
Well,
it means the lifespan of the law as it is would begin to run when the referendum approves of it. If the referendum rejects it, it dies.
My Lords, it would have lessened on the absurdity of this provision. It would be less absurd, but still it will not be very good. Because under Article 1 of the Constitution, Parliament is supposed to make laws for the people, in the name of the people. Now, when you sit as Parliament, 317 MPs, and say that I think there should be a referendum so that we harmonize these positions, and you put it even in an act of Parliament, that one is not correct. It is contrary to Article 79 of the Constitution, and even usurps the people's power under Article 1, because now they will not be acting in the name of the people. They are acting only from their own point of view. Because, even for a referendum, there should be a bill. It has to be originated by a bill. And there must be people participation. So after they have participated, then a law is put in place. When a law is put in place, the question is sent to the judges or whoever to formulate. So, my Lord, even the referendum itself, elaborately under Article 255 of the Constitution, is a process. It's not an event. It's not something you just say, let us say that there will be a referendum. So, my Lords, my argument here is that Article 79 of the Constitution was breached by Parliament when they purported to make a law on a mere suggestion of something which has no value as a law. It has no value as a law because a law must create rights or liabilities. Now, in this case, what does it create? Nothing. It's a mere suggestion.
Yes, my lords. You are dealing with Section 9
of the Act,
or the whole Act.
The whole, not the whole of the Act. My lords, I'm talking about issue.
Section of the Act.
The section of the Act.
Section 9 of the Act, my lords.
That is amending the Article 289.
Yes, my lords.
What is suggestive there?
My lords, Article 289A, clause Article 105 shall come into effect upon dissolution of the Parliament in existence at the commencement of this Act. You see, my lords, when you say it will come into effect, it means a referendum will have been held and the 7-year period starts running. You cannot assume that the people will have decided that the president should be given 7 years. You cannot make that assumption when it has not been held. So, my lords, the nature, the manner in which this matter is forged is speculative. You're just speculating that the people will have decided. It's as if
the manner it is called in the Constitution or in the Act, the amending Act.
it is the amended Act.
Okay.
It is
The amending Act.
the amending Act. The amending Act. It may be already part of this Constitution, but it does not make sense. It is absurd. My colleagues have already talked about the effect of amending Article 105.
Mr. Rakafuz, just to help you, it's not about the effects of that article. This Section 9 of the amending Act, how you proposed the issue which court has adopted and framed, is, your case is that Section 9 of the amending Act contravenes or is inconsistent with Articles 105, 26. That's why I said you need evidence. You get what I'm saying? I don't know if you come out clear on that. Maybe I missed.
My Lord, it would have been more decent. I would have been better prepared after cross-examining the her.
No. Let's not go back because I overruled you on that.
Yeah, okay. You overruled me and I'm sorry.
And you're on record.
Yes.
Although the facial expression is not recorded, yes. But you're on record as having not been very happy when I overruled you. That one is on record.
Yeah, that is very nice.
Yes.
Yeah. So, my Lord, it seems
You know, Mr. Wakafuzi, I during conferencing, even here,
yes, my Lord,
I've been very clear. I even, without you moving me, I moved the hearing of this case from 4th to 9th. That's 5 more days, 1 full week, so that we are all prepared. And I was very clear. I stated in no uncertain language that it will be a marathon hearing. So if you're not prepared, then we submit without being prepared. If you're prepared, we submit. On that one, I'm not going to compromise.
I have already submitted.
No, I'm not saying you've not submitted it. If you've concluded, you tell me, and somebody else will follow.
Yeah, I have already submitted that this so-called amendment.
No, it's not so-called amendment. It's already an amendment. You know it as a lawyer.
My Lord,
of course, we have powers to question. We cannot question a so-called. We have to question what is already part of our legal regime. For good reasons which we would have given, we will question it, and the status quo obtaining before will come back once it is questioned.
Prudential, with over 170 years of existence. Don't worry about your child's future education. Be happy with True EduSave and let's face life together. Turinawi. Prudential.
Teens are taking over. Banter marketing.
To successfully transition from campus to your dream job, you need the right connections. And it all starts at the NSSF and Daily Monitor Career Expo. So come, interact with established entrepreneurs and corporate executives and get hooked with the opportunities to enable you build a strong business empire or corporate career. This year's Career Expo will take place at 11 universities around the country between 1st March and 6th April 2018. Don't miss this career building opportunity. Visit nssfug.org or check press and posters to find out when the expo will visit your campus. The 2018 Career Expo is proudly brought to you by Daily Monitor and
NSSF, a better life.
Sorry, there just isn't any opportunity.
If opportunity won't come to me, I'll create it.
Have no fear, the opportunities are endless with super data and swift bundles on MTN Pulse. Hit *157# to join MTN Pulse and activate Pulse bundles.
Everywhere you go, MTN.
Lwaki okozesa sabbuuni ono?
Kubanga atukuzanga sabbuuni yenno wa bulijjo.
Eriyo agiramu ddala amabala gonna mu lwoza lumu.
Tekisoboka.
Weetegereze omuddo, caayi w'amajaani ne chocolate.
Nja kumwetaaga. Embatu 2.
N'olubatu lumu lwokka olwa Ariel. Olabye? Aggyemu amabala gonna.
Oba olonze bulungi.
Ariel aggyamu amabala amazibu gonna mu lwoza lumu lwokka.
We're going
to build the wall. We have no choice.
We condemn the banning of the Holy Scriptures in the strongest terms.
Economic activity is projected to grow to an average.
The Prince captain does well and takes a strike and it's
Honorable right of opposition. Please take your seat first. Take your seat.
I cannot koto in their puhu.
We have made sense of the events around you, putting political, health, social, cultural, economic, technological, entertainment, and sports issues into perspective for all Ugandans over 25 years, reaching up to 20 million Ugandans. Today, our commitment to telling the truth through incisive journalism hasn't waned. So, to speak from the truth's point of view, read the Daily Monitor on your smartphone, tablet, laptop, and in print. Daily Monitor. Truth every day.
Today's lesson is pimples, 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 and also pimples.
Pimples?
Block out the breakout with new Protex Deep Clean, which removes dirt and oil that can cause pimples and eliminates 99.9% of germs.
Whoa.
Hi. Help remove oil and dirt that can cause pimples with Protex Deep Clean.
To successfully transition from campus to your dream job, you need the right connections. And it all starts at the NSSF and Daily Monitor Career Expo. So come, interact with established entrepreneurs and corporate executives and get hooked with the opportunities to enable you build a strong business empire or corporate career. This year's Career Expo will take place at 11 universities around the country between 1st March and 6th April 2018. Don't miss this career building opportunity. Visit nssfug.org or check press and posters to find out when the expo will visit your campus. The 2018 Career Expo is proudly brought to you by Daily Monitor and
NSSF, a better life.
The Institute of Internal Auditors Uganda was founded in 2002 and is affiliated to the Global Institute of Internal Auditors. Its mission is to advance the internal audit profession and practice in Uganda, particularly in the areas of governance, risk management, and internal control in both the public and private sectors. Join us this Wednesday, 11th April, here at 10 p.m. for the live talk show on how the Institute of Internal Audit Uganda has put programs in place intended to reduce the levels of financial mismanagement and corruption in the country through the promotion of integrity, courage, service excellence, teamwork, and innovation. This show is brought to you by
Kaye Samwiri ndi muvuzi wa mmotoka era nga nvuga loole y'amafuta. Naye bwe mba sinnasimbula loole eyo nsooka nenkebera emipiira, nenkebera amazzi, nenkebera oyiro, nenkebera brakes. Bwe nsangako ekimu nga si kitereevu sisimbula, bamala kukitereeza.